In the Second Circuit's decision in Maloney versus Cuomo, you in fact recognize the Supreme Court decided in Heller that the personal right to bear arms is guaranteed by the Second Amendment of the Constitution against federal law restriction. Is that correct?
It is.
And you accepted and applied the Heller decision when you decided Maloney?
Completely, sir. I accepted and applied established Supreme Court precedent that the Supreme Court, in its own opinion in Heller, acknowledged, answered a different question.
It was a 5-4 decision at the U.S. Supreme Court today. The case, McDonald versus the City of Chicago. The Supreme Court held that the Second Amendment right to bear arms applies through the 14th Amendment, the Due Process Clause, to all 50 states. Now, gun ownership advocates hailed this as a monumental victory. This, of course, comes on a day when Elena Kagan started her confirmation process with the first day of hearings.
Well, what I thought was so interesting is the timing. I mean, this happened as Elena Kagan kicked off her confirmation hearings. And very quickly, we saw that this ruling translate into that hearing room. We had Democrats, some Democrats like Dianne Feinstein condemning it. We had Republicans quickly pouncing on this and saying, hey, look, this is another reason why we need to question how trustworthy these Supreme Court nominees are, because they harken back to the Sotomayor hearings, during which she said that gun ownership, the Second Amendment, is a fundamental right, and yet she was on the dissenting end of this decision. And so they were using that to say to Elena Kagan, well, can we trust you? So what you're saying here is going to hold up when you're actually on the bench, if you make it to the bench.
I will listen hard to every party before the court and to each of my colleagues. I will work hard, and I will do my best to consider every case impartially, modestly, with commitment to principle, and in accordance with law.